Hello, this is Attorney Doug Jones. Welcome today to Elder Law in 5 Minutes. Today we're going to be talking about a recent newsletter article, Is It Better to Have a Will or a Living Trust? And so, by the way, if you don't get our newsletter, it's free. Just go to elp.legal and you can sign up for it. But say you're starting the planning process and you're thinking about, should I have a will or should I have a trust? After all, they do pretty much the same thing, which is distribute assets at death, but there are substantial differences, and one of the biggest differences is probate. If you got a will, you go through the probate process. So what happens there? The court will review your will along with testimony and other evidence presented at the court proceedings, and at the end of the probate process, the court will authorize transfer those assets from your estate pursuant to your directives in the will and the findings of the court. You can see why you'd want to avoid that. And most people think, or a lot of people anyway, think if they have a will, they're going to totally bypass probate or avoid probate. This is not true. If you've got a will, you've got assets titled in your name, and when you die, those assets are stuck. They're still just in your name, and you can't get them out of your name because you're dead. So someone's got to probate your will to get those assets legally retitled from your name to the name of the trust. Your will is what you want to happen. The order of the probate court actually makes it happen. So what about privacy? Well, there is none with this process. If you got a will and the will is filed in probate court, then the will is public along with all of the documents that are filed in the probate proceedings and any testimony that may be presented in any court proceedings as part of the probate process. Time lag usually takes 6 to maybe up to 24 months. We've had them even go longer to go through a probate proceeding here in Arkansas. And during this time, the estate attorney and the executor can be paid statutory fees, sometimes more, sometimes less. And of course, that's also controlled by discretion of the court. If you got more assets in more than one state, maybe property here and property in another state, there can be probates in each state. So double expense, double the fun. You can see why a lot of people would want to avoid this process. And the way that people do that sometimes is with a revocable living trust. This is obviously not a revocable living trust. It's just my little wooden box that I like to use for show and tell. But think of this trust as a box, and you own the box. It's your box, it's your trust. You control it. You can open it up at any time. You can put assets in a trust. You can take them out at any time. You're in full control your whole life. Anytime if you bought another house, you just have it titled to trust. Open a new bank account, have it titled to trust. And you name successor trustees who would step in your shoes and distribute assets at your death. You just say that up front. And when you die or are incapacitated, your successor trustee takes stuff out of your box and distributes them. So usually a lot more control. What are some other considerations, will versus trust? Well, cost is obviously one thing. It costs more to prepare a trust than a will because a trust is more complex, at least on the front end. Once it's set up, well, then that's it. It just goes along as you set it up and you're in control of everything. Hassle is a big thing. It's no hassle to you after you die because obviously you're dead, but for your kids, hassle's a big thing. So wills and probate, you may want to help them avoid that, and if so, well then a trust is a way to go to avoid the probate. The time lag, again, 6 to 24 or so months to probate a will. With a trust, it's immediate, or they want to make sure your bills are paid first before they distribute assets, but there's no court process associated with a trust. And privacy, with a trust and probate proceeding, there is no privacy. It's all public documents, public record. And with a trust, it's owned by you and your family, and it's private, and the only people involved are just your family members. So there's a lot to think about when you're doing your estate planning process. If we can help, just give us a call. If you're in Arkansas, 501-843-9014, or go to our website at arcelderlaw.com. I hope this information is useful. If we can help in any way, please give us a call. And by the way, if you haven't subscribed to our YouTube channel, click that subscribe button and hit the notification bell so you can be notified of future videos that we do. If we like this and it was helpful, give us a like. Thanks for watching today. Have a good day.